I'm asking you whether you think Lord Janner's death, and therefore the fact that his trial of the facts, as it's known, that was due in April, we are told as things stand it won't take place, whether you think that will put people off coming forward and revealing that they were sexually abused when they were children. It was interesting to hear Lord MacDonald this morning, the former Director of Public Prosecution, saying that his own preference would be to drop the case, but he didn't think it was impossible that the trial of the facts, which would take place in the absence of a living person, there's no reason in common sense terms why it can't take place in the absence of the person because they are dead. But Lord MacDonald says in his view, his preference is to drop the case because he felt, quotes, there was something unseemly about a criminal process to determine the acts of a person who's already died. He said it would be a groundbreaking proceeding if it happened, and probably groundbreaking in an unfortunate way. That's what Lord MacDonald, former Director of Public Prosecutions, thinks. The Crown Prosecution Service, about an hour and a half ago, revealed that it hadn't ruled it out, that it would be considering what it called the procedural implications of a trial of the facts involving a person who has already died. Joseph Kotrie-Monson joins me now, criminal lawyer at the Mary Monson Solicitors on Fleet Street. Good afternoon to you, Joseph.
Good afternoon.
Do you believe it will go ahead, the trial of the facts?
Well, what I believe is irrelevant. I have seen so much in this case that has been so disquieting from the outset. This is just another dissatisfactory twist in the history of this case. First, the investigations over the decades mysteriously dropped. Then the sudden retirement by Lord Janner from the House of Lords, his rapid diagnosis with dementia, and the very suspect way in which the CPS decided to charge, and then having taken advice, which was actually positive advice to charge, decided not to charge amid claims that they'd been interfered with by people close to Lord Janner. Then a decision is made. Of course, we had the fiasco in Westminster Magistrates Court when an attempt was made by Mr. Janner or those around him to refuse his attendance. I've never known anything like it. And then a decision made in the Crown Court by a judge that he was not to plead, which some people, I have to say, not me, are very suspicious about still. We've got another alleged paedophile in this horrible affair over the past couple of years who has died without facing justice again.
You say what you think doesn't count, but just indulge me a bit, Joseph, on this, because what I want to get from you as a lawyer is, Lord MacDonald says his preference is that this shouldn't take place because the man has died. This trial of the facts shouldn't take place because he's died. He thinks it would be we know it would be groundbreaking, but he believes it would be groundbreaking in an unfortunate way. Do you believe it would be unfortunate, or do you think it's an absolutely viable option?
I can't see anything in the argument that suggests it was unfortunate, because the purpose of a trial of the facts is not to punish the offender. It's not to punish the person who's committed committed any offences. It's to get to the fact. In fact, the defendant in such cases, their presence isn't even required. That's why it's called a trial of the facts and not a trial of the defendant. The purpose is to serve justice to the victims by having it publicly acknowledged what occurred. You know, that's what the purpose of these proceedings is for. There should either be a trial of the facts or there should be a judicial inquiry. What, of course, people are hoping, who are trying still to protect the reputation of this man, is that this will just be lost in the matrix of a very long, waited for, all-encompassing inquiry, which we know we're going to get the outcome of in about 5 years' time. And Lord Janner's involvement or otherwise will just be a minor footnote in all.
Are you talking about the Goddard inquiry when you talk about that?
Absolutely. And you know, the reality is that this is a matter where we're talking about somebody who was at the very peak of politics 4 decades, against whom it's alleged he took children out of specific children's homes, different children, 22 offences they were considering. You know, this is a horrific set of allegations, and the victims in this case deserve justice. And you know, I'm a defence lawyer. These are not things that I would ordinarily be expecting to say, but this is a case that if true, repulses everybody on both sides of the.
We're expecting some kind of announcement as to whether the Goddard inquiry will specifically take on those 22 allegations that you talk about. Do you think that the inquiry has to do so, particularly if the trial of the facts doesn't take place, that it has to do so if it's going to send the message that this is real? The investigation is real.
If these 22 offences are not as they should be considered by a tribunal on their own, and there's no argument. Again, there's no argument that they shouldn't. Then the idea that this then shouldn't be given at least a very special and intense and open scrutiny in the context of the Goddard inquiry, I would be both surprised and depressed if that didn't happen.
All right, thank you, Joseph. Joseph Kotrie-Monson, criminal lawyer at Monson Solicitors.